Hey guys, so today we are rocking the live stream only laptop, so we shouldn't have any weird hiccups like the last time. This one's never crashed before, so hopefully we can keep that streak alive. We are going to watch this video because I love this video. So this came out, I believe it was today. If you recall, a long time ago, and by that I mean like a month or two ago, this guy came to court. He's trying to get out of a not live. No. He's trying to get out of a drunk while boating ticket offense, whatever. He's the one who also, this is the drunken boat guy. That is exactly who this is. If you recall, he tried to bring in a Native American professor of some nonsense. And they're like, "Are you an attorney?" And they're like, "No." And he's like, "Okay, what's the point?" JCAR member for 14 months, dear Lord. Good evening, Sovcits keep on giving. Yes, they're the unwanted gift that keeps on giving. But yeah, so this guy's just been having some trouble. And if you recall, shortly after this case, that Lady Sovcit got into all of her trouble for pretending to be an attorney in this very courtroom. But yeah, he's not going to do any better. He's going to, I don't know how to explain this correctly. He's going to claim that some of the things the officer, why do you guys make fun of someone for knowing their rights? I have yet to see anyone that I've been making fun of that actually knew their rights, but thanks for playing. Again, so this guy doesn't know shit. Thanks for bringing that up. They don't know shit. He wants to play the Native American card to get out of it, but that's not how that works. And I believe it's not a normal police officer. You guys, it's in Michigan, so I'm assuming it's like a DNR officer or a conservation officer, yada, yada. That's who busted him, basically. Okay. Again, if I desync the voice in the video, let me know. I don't think we'll have an issue, but here we go.
And our first case on the morning docket is People of the State of Michigan versus Trevor McLeod, file 23-6748FH. Good morning, Mr. McLeod. And still your intention to represent yourself in this matter?
That's correct.
And Mr. McLeod, this is scheduled for a docket call, but also you filed a motion to reconsider the court's denial of the motion to suppress. I've reviewed your motion. Go ahead and say anything further that you wish to in its support.
I mean, I think it's pretty well laid out in my motion to reconsider.
Thank you, Mr. Juliet. People have a position?
No.
All right. Well, Mr. McLeod, I mean, your motion to reconsider is that this court doesn't have the authority to interpret the consent decree, and that you don't have to announce your status as a tribal member to DNR officers in order to be protected by the provisions of the consent decree. I'm assuming that those statements that you make are true, but it's my opinion that doesn't change the ruling in this case, because if you were charged with some kind of boat registration violation or something,
Which I was.
those may well be. Well, but that's not the violation that's in front of me.
Well, that's the initial violation for the whole reason why I'm here.
Right. But if you were charged with that, this might well present a defense. But what I'm saying is that doesn't invalidate the officers having contact with you, because they have no idea who's who out there.
Right.
So to accept your argument means that they just don't get to that tribal members could just go around and they don't.
Parsons, it's actually funny that you said that. Because I just watched the Unclean Hands video. I'm imagining a couple other people did it as well. The frauditor lawyer who just got basically the bar of whatever state, Oklahoma, I want to say, could be wrong, one of those states, basically said, yeah, you do X, Y, and Z. You can't be a lawyer here. Sorry. So now he can't practice law in, like I said, Oklahoma, because he wanted to do the whole nonsensical frauditor thing. And just the British registry. Oh my God. Craig, thank you for the 5 gifted memberships. Back to the video.
They don't even get to get stopped when the police don't even know who they are.
Well, I think this is because they're supposed to be trained to ask if we're tribal or not. Well, and in fact, in the consent decree, for them to even be qualified to handle or deal with tribal members, they're supposed to have cultural sensitivity training. And I can tell you right now that I've called my tribe and they're not on any list that's that has had that training. So they're not even qualified to approach or ticket or do anything with tribal members until they complete that training, and they've never done it. So,
Well, the testimony was that the officer, immediately upon initial contact, did detect indications of impairment, and then
right, but I also proved that he perjured himself, which means his testimony is junk.
so based upon his testimony, the stop was good, the investigation was good, and the motion for reconsideration is denied. So what that does, sir, I don't even know who you are, but you guys stop interrupting the process. Right?
I'm sorry.
Okay, you can observe, but you can't participate. You understand there's a difference there.
Okay, and I'm glad that happened again, because if you recall, the lady sovereign citizen that happened right after this guy's, I want to say, original hearing, somebody did exactly the same thing, where they were just sitting there and then wanted to be part of the actual case and trial. And it's like, that's not how it works. Oh, dear Lord, I missed some things. Let's see here. Yvonne Gush Queen for 5 gifted memberships. Thank you. JCar for 5 more gifted memberships. You guys are awesome tonight. But yeah, I feel bad for this judge. There's a couple judges that I feel bad for. I know I'm going to leave some out, but this Judge Simpson, seems to just attract crazy people. Oh, what's the other guy? Judge Middleton attracts crazy people. They're all Michigan judges, which is hilarious. Oh God. The one judge who got her channel taken down because somebody wanted to prawn bomb the YouTube court hearing, that judge attracts crazy people. I just feel bad for them. They don't get paid enough to deal with these people. Oh my God, Judge Perkins. I totally forgot it. Judge Perkins is the top of the pyramid for who attracts the crazy.
All right, so Mr. McLeod, then you previously stated that it was your intention to file an application to appeal the Court of Appeals. Are you still seeking?
Well, currently what's going on is I'm filing a criminal complaint against these officers and probably a civil complaint. So I'm gonna make a move to stay the court, motion to stay the court for a bit while I get these complaints going. Again.
Okay, well, I was going to say Parsons gifted 5 memberships, but then right after that, I read this comment. I never accept gifted memberships. I did that on Massel Report and wound up a John Doe defendant in a Chile de Castro lawsuit. That's hilarious. Michigan is getting as bad as Florida. You're not wrong. I'll walk that one back a little bit. I feel like Michigan gets a bad rap because yes, we have, Florida man equivalent people here in Michigan, but it's because all of our courts are still like, oh yeah, this was good for us. Let's just keep it on YouTube. So now everything gets thrown on YouTube. So every other state can see our crazy people.
And get them to the right authorities.
Well, I'm not going to do that. I mean, it's one thing, sometimes when people are appealing a ruling, that's different, but you're saying you want to pursue criminal or civil remedies against the officers. I don't even know what those would be. But I'm not going to stay in this case for that. Well,
I've also got 5 more motions that I've already written and I'm returning to, so I need some time to sort this out.
Well, when are you going to file those?
I'll file one today,
Well, here's the deal, like you should file all the motions you want me to hear, and then I can hear them. And then if they resolve the case, great. If they don't, then we'll set it for a jury trial. What we shouldn't ought to do is just kind of trickle them out so this case lasts, 2 years or something.
Yeah, your first move should always be to sue the judge. Yeah, that's absolutely not the case. Again, somebody said Judge Perkins earlier. That literally happens to him all the time with sovereign citizens, and just goes, "Yeah, no, we're not going to do that. You can sue me all you want. I'll win, but you're still going to get charged with this."
So what I was thinking I could do today is give you a jury trial. But if you've got some more motions to file, I'll put it out for another docket call, but that'll be a motion cutoff, meaning that any arguments you got about this case, file them all, and we'll hear them all. Does that make sense?
I guess so.
Okay. So let's pick a date for that. What about April 23rd? That's in about 5 weeks. That should give you plenty of time to get your motions filed.
Yeah, that's right.
Okay. All right, so let's schedule this then for a docket call, and that'll also serve as a motion cutoff for April 23rd at 9 a.m.
I'd like to have Officer Liestenfelds and Beelman present for questioning.
What?
Could I have Officer Liestenfelds and Officer Beelman present for questioning that day?
Well, it depends on what motion you file.
It's gonna have to do with their testimony.
Okay, so if you file a motion that requires the testimony of the officers, then how that generally works is when you file a written motion, then the prosecutors, on notice that in order to respond to that motion, they have to bring the officers to testify. What motion do you think you're going to file that requires their testimony?
Well, I'm gonna. So in Mr. Liestenfeld's report, which you probably have in front of
I don't.
you,
I only get what you guys give me during motions.
I submitted it all. It's all in the clerk's
Okay.
file. But he states in his statement that once the warrant was signed, that I gave him my blood without cause, but in my documents, I've got an unsigned warrant. It was never signed. So his testimony is impeached also. They're both lying.
Okay, so you're going to file a motion to.
So his whole defense is based off of, I don't think these documents apply to me, therefore no one's testimony is accurate. That is his whole defense.
Suppress was there a blood test? Yeah, blood test, okay, and that would require the officer's testimony, so, all right. So yes, if you file a motion like that, Mr. Giuliano will bring the officers.
Okay.
Otherwise, he would probably lose the motion because it's his burden to come forward with that evidence then. All right. All right, anything further today then, Mr. McDowell?
Oh, good enough.
Okay, we'll see you April 23rd at 9 a.m. All right. All right, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. Up first this morning, we've got People of the State of Michigan versus Trevor McLeod, file 23-6748FH. Counsel for the people, you want to state your appearance, please?
Anthony Giuliano, people.
All right, and Mr. McLeod, good morning, sir.
Morning.
Again, every time we come into court, I'm going to be required by the court rules to confirm that you wish to represent yourself in this matter without the assistance of an attorney.
That's correct.
All right. We're here for a docket call as well as several motions that you filed up, that you noticed up. One of them does require some testimony. That was the motion to suppress the chemical test results. Your filing the motion triggers the prosecutor's burden to establish that search was taken properly. Is there any opening statement you want to make, Mr. McLeod, about your motion to suppress the chemical?
Okay, so I'm just going to break this down real quick. So it seems like our sovereign citizen friend here decided he was going to, oh God. So you have the little roadside breathalyzer that you can use. God, what's it called? The Data Master, some nonsense that every police department normally has in their booking room specifically for drunk driving. You read them there. Oh, you have the right to do blah, 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 blah. Some people choose not to blow. When they don't do that, okay, cool. Sit in this cell real quick. We'll type up a warrant. We'll send it to whatever judge is responsible for this nighttime shift. We'll send it to them, say, yeah, we got them for drunk driving. They don't want to blow. Here's the warrant for the blood test. They sign it, send it back, and it is what it is. And then you take them to whatever hospital is closest. Where I worked, there was like 4 that we could go to. But yeah, and then you get your blood taken, and that's what it is. It's a warrant for your blood. You don't really have a choice. So yeah, you'll find out he said, I'm not gonna do any of your tests. So they just said, okay, cool. We're going to get a warrant for your blood. That's what they did. And he doesn't like that.
Test results. And you'll have an opportunity to argue after the testimony as well. Any opening statement you want to make?
Well, I just received an email from the from Julie Rattel. I don't know if she's a court administrator or clerk.
She works in the prosecutor's office.
Okay, I just received an email from her on Friday with the warrant that was never found in Discovery or anywhere. It just turned up Friday magically, I guess.
And they'll explain that. Just give them a second.
Okay, Mr. Juliet, any opening statement?
No.
All right, and your witness?
Conservation Officer, Burgoyce.
All right, Officer Burgoyce, would you please raise your right hand for me, sir? Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Go ahead, Mr. Juliet.
Sir, can you state your full name and spell your last name for the record?
Alexander Bourgeois, Bourgeois.
Thank you. And where do you work?
DNR.
How long have you worked there?
I got hired in July. I've been working the field since August of 2022. So 2022.
Okay. Were you working on September 4th of 2023?
Yes, sir.
Okay. And did you have some interaction with the defendant, Trevor McLeod, that day?
Yes, sir.
Is he present in the courtroom, if you can see?
I can't see, but I saw him earlier. He's in the defendant seat.
All right, can I let the record reflect that?
September 3rd.
Can I let the record reflect the officers identified the defendant?
Yes.
Thank you. Can you describe what caused you to have contact with him?
Initially on that day, we were doing a BOI patrol, and other COs notified me and the other officers that were in my patrol boat that there was a boat with expired registration. We went to the Forks boat launch to make contact with that vessel, and subsequently we found out that the defendant was intoxicated while he was operating the vessel, and that led to the arrest of him.
How did you find out he was operating while intoxicated?
Once he had exited the vessel, I noticed that he had to use the post on the dock for his balance to get out of it. He took off his sandals, then walked to the bathroom, and as he was walking, he stumbled and swayed back and forth along the dock and up the ramp of the boat ramp to the bathroom. And then the same thing coming back. Myself and other officers observed this, and that's when we made contact with him.
Okay. When you made contact with him, were there any other signs of intoxication that you could tell?
Hey, the adults are talking. Yeah, it's weird to hear the word vessel used correctly when a sovereign citizen is involved, but yes, he's 1000% using it correctly.
Yes, while talking to him, I observed slurred speech. When I asked him for his documents for his boat and his driver's license, he lacked fine motor skills. I couldn't pick through the papers. That's a common sign of intoxication. And then when he was stepping into the vessel to go get the registration for the vessel, I noticed that it took him about 10 seconds just to put on one of the sandals that would show that he was lacking fine motor skills, couldn't put his foot inside of the sandal to put it on.
Did you perform any standardized field sobriety tests?
No, sir, the defendant refused.
So what happened after he refused the field sobriety test?
Myself and Officer Listenfeltz, we advised him that he was going to be under arrest for BUI and asked him to exit the vessel that he was in. He refused, even though we gave him a lawful order. We told him that if he didn't exit the vessel, that additional charges would be brought against him, resist and obstruct. He still refused to. Officer Listenfeltz got inside of the vessel with him. We told him to place his hands behind his back, that he was under arrest. And Officer Listenfeltz went to grab his arms to put his hands behind his back. The defendant pulled away from Officer Listenfeltz, and during this time, a scuffle erupted, and Officer Listenfeltz fell on top of the defendant. He put his arms in front of him so that way he couldn't be cuffed. During this tussle, Officer Listenfeltz was able to pull his left arm behind his back and put a cuff on it, and then the defendant still kept his right arm on his chest. At this time, I pulled out my taser. I took the cartridge off so that I could use the dry stun option. I had to tell him 4 times that if he didn't comply, he was going to get tased. And then finally, Officer Listenfels was able to pull his right arm behind his back and handcuff him.
I can swim extremely well. With that being said, I am not going to, if I'm an officer, I'm not going to fight a subject on the dock while he's drunk. And if I'm a subject, I'm not going to try to fight a cop while drunk on a dock. Like, that's just not a good look. Especially if an officer falls into the water with all the gear. That's a no-go for them. A drunk person falls into the water. That's a no-go for them. I'm just going to pass on all that.
So at some point, did you arrest him for boating under the influence?
Yes, sir.
And is there a procedure within the Department of Natural Resources for what to do when you arrest somebody for boating under the influence? Do you draw blood, or do you use a data master or anything like that?
Yes, sir. It's the same as if it was a motor vehicle. Obviously, with how he acted, we knew that he was going to refuse. So once we got to the jail, the Sheboygan County Jail, Officer Listenfels went and read him his DI 177, which I think it might be called something else for DUI, but his chemical test rights. And then I started typing up the search warrant because we knew that he was just going to refuse. And then we went and got the search warrant for his blood.
Okay. Do you know if he actually refused or?
Yes, sir.
Okay. And you said you were the one that typed the search warrant?
Yes, sir.
Do you have a copy of the search warrant with you?
I have it about 10 feet away from me if you'd like me to grab it.
Sure, Officer Bourgeois, if you want to go retrieve that.
I object to it. It is as exhibit. This
Well-
just turned up on Friday.
Okay, well, it hasn't been offered just yet, but you're about to offer, right?
Yes.
All right, so the objection is that it was not provided during discovery.
During 3 different requests for discovery.
Any
Well, I don't
response to that?
I don't know. I mean, it's his motion to suppress the search warrant. I mean, I think I should be able to offer it as evidence.
Right, well, I mean, do you have any response to the discovery objection that it wasn't provided, or?
I do. We didn't have the search warrant in our file. We had to call up to the jail last week and get it. So when we got it, that's when we emailed it to them.
Okay, that objection, Mr. McLeod, to be overruled. It's far in advance of trial. We haven't even set a trial date. We might end up doing that this morning yet, but we don't have a trial date.
So if we're allowed to keep bringing discovery, I'd like to allow my witnesses that I forgot to call for their discovery to be brought into the case also.
For what? For what purpose?
For the trial.
A trial, yes, we haven't even, so if I set a trial date today, there'll be a deadline to file witness and exhibit lists. Okay, you'll be able to do that. Yeah, discovery's just got to be done well in advance of trial. And for purposes of responding to your motion today, then it's appropriate. All right, go ahead.
Officer, do you can you recognize who's the magistrate or the judge that signed the search warrant?
The signature is in cursive, but it looks like the first name is Mariah and then Ellen Bowe. It's hard to read the last few letters of her signature, but it was a female that came in.
And what date was that search warrant issued?
9/3 of 2023.
If I can approach for people's proposed one for admission of people's one.
All right, any objection to the admission of people's
Yeah,
exhibit one?
it's invalid. It doesn't have any details. It doesn't have a charge. The affidavit that's supposed to go with it is signed by a judge or by the officer. And it's completely procedurally incorrect. I wasn't provided a copy or shown that warrant at the time of arrest. I haven't had a copy of the 3 requests for discovery.
Okay, those objections are overruled. People's exhibit one is admitted.
May I continue, Your Honor?
Yes.
Officer, did you serve the search warrant on the defendant?
Yes, sir.
And where was that at?
It was at the Sheboygan County Jail.
Okay. And did you subsequently observe blood being drawn?
Yes, sir. Both myself and Officer Listenfels were in the room.
Any questions for this officer?
Yeah. So on the day that you were out on saturation patrol, could you explain what saturation patrol is? in detail?
So, yes, sir. So, what we're looking for is it was a busy time of the year,
broken system,
boating
broken
season.
trucks.
So, what we'll do is we'll put a lot of officers out whether it's on the water or on land, that would be used for transportation if an arrest is made. But we look for BUI, anything to do with alcohol violations. So if we came across someone that was under the influence of boating, typically we either have officers that would take them to the jail for us, or that could go and patrol our area once we did that. But it's a large number of officers in the area specifically looking for BUI and safety issues with the boating season.
And all these officers have a pretty good training on the laws of OWI and have training on how to perform and execute these arrests.
Yes, sir.
Okay, so are you aware that according to the Natural Resources Environmental Protection Act, section 324-80176, subsection 3, that in order to approach anyone or board their vessels, if you suspect an OWI, the suspect has to be physically impaired while underway?
Sir, you were underway. I think we covered this in the first motion you filed.
You never noted that I
They
was
did.
physically impaired while I was underway. In fact, you said that you did observe me through binoculars to see if my registration was expired. Is that correct?
Yes, I did use binoculars to see you underway with the vessel and that your expiration was expired. Yes.
Okay, the reason why you approached me was the expired registration. Is that correct?
Well, we docked next to you to talk to you about the registration, but once we docked next to you, then we observed the signs of impairment, which even if you didn't have expired registration, I still would have made contact with you because of the reasonable suspicion of intoxication.
Okay, when you report.
So just to throw this out here, imagine how ridiculous this would be if every time it says conservation officer, let's go with that. If every single time they wanted to come up to your boat and check anything, they had to literally stop you, pull you over like it was a traffic stop, when they could just sit in their own little corner of the lake, minding their own business, letting everybody else do what they wanted, and then go, oh, yeah, binoculars. Okay, yep, that guy doesn't have a registration. Oh, that guy's doing this while he's by himself in his damn Skeeter bass boat. Like, this guy wanted him to apparently get on his boat, watch him drive poorly or like he was drunk, and then initiate some sort of water traffic stop.
Reports you state the reason you and your partner approached me and my family was due to an out-of-date registration. Is that correct?
That was one of the reasons, yes, sir. But again, we would have made contact with you regardless of the registration because of the stumbling and swaying up the ramp.
Is it common protocol to run a boat's license number on vessels that have expired registration?
I can if I want to double check that it is actually expired, which typically I would do that if you could provide some type of registration that would prove that it wasn't. That's when that would run the number through lien to see if it actually was expired. And that if it wasn't expired, then we'd go through other avenues such as failing to display the new decal.
Okay, so would you admit that you're trained to notice out-of-date registration stickers on boats and off-road vehicles?
Yes, sir.
Is it safe to say that you likely noticed my out-of-date registration when we were actually launching our boat right next to you?
Well, we noticed your registration. Well, the other officers did notify us of it, and then we went to the scene, observed that you were the driver that they stated was driving, that you were the vessel that had the expired registration. Everything matched, that we had the correct vessel that was pointed out by other officers, and that's when we docked next to you. Yes, I mean,
so that day, Mr. Bourgeois, that day I launched my boat right next to you guys launching into the water around 2:00. Is that correct?
not that I'm aware of.
Okay, so when I was swimming with my family out in the lake and you guys rolled by us very slowly with no other boats around and waved at us, you didn't notice my registration then?
Well, so there was probably 10-ish officers. It probably wasn't me because I don't recall. And if
Also, common sense tells you, if you see a family swimming in the lake and you're, driving your boat, you're going to slow down because the last thing you want to do is just wave after wave over a bunch of little kids. Oh, Michigan is giving me some weird weather. That's what it's doing right now. It's going to be 60s, 50s, and 70s this week, but for some reason have a low of 28, which is weird. But yeah, they slowed down, not to check him out, not to do anything, but just to, I don't know, be a decent human being and not just wash their little kids and drown them.
If that was you, sir, obviously we would have.
Yeah, that's fine. You answered my question.
Okay.
Is there a safety measure in place for officers to be sure that they're not encountering Native Americans on the water as they do not need registration? How do you approach that situation?
Well, sir, we treat everybody as if they're state fishermen or recreation. Once we make contact with the individual and they advise us that they are tribal, depending on what treaty they're in your case, the Sioux tribe in the 1836 treaty, we do have the jurisdiction to still check that you have everything that you're required by your tribe and continue a check. And if you don't have the stuff that you need, so say you're spearing, you have to have special permits that the tribe notifies.
Did you search my vessel that day to check and see if I had the required stuff?
No, sir, because you weren't in the act of fishing. You were driving the boat just down up the river.
So you didn't search my boat to see if there was any equipment that could indicate that I was fishing?
No, sir, because it's not applicable to the violation.
You didn't search. So you didn't search my boat, is that correct?
No, sir.
Do you have any evidence that at the time I was operating the vessel that my BAC was over the legal limit?
I had probable cause to believe that you were intoxicated upon the arrest.
That's not what I asked. Do you have any evidence?
Well, Mr. McLeod, that's not even relevant to the question here today.
Well, this whole thing is irrelevant. I mean, it's all based on hearsay and what these lying cops are talking about.
Well, this is a motion about whether the results of the blood test are admissible. So if you can direct your questions toward that question.
You say you obtained a warrant to draw my blood. That's correct?
Yes, sir.
Why wasn't I shown or given a copy of the warrant upon release?
Myself and Officer Listenfelds actually left copies with the jail, as the prosecutor stated earlier. That's why they weren't sent by me to the prosecutor. I have the affidavit and the search warrant right next to me. I believe they made copies, or at least we left the return and tabulation, which you're required to by law. So that was left for you at the jail by us, and Officer Listenfelds could testify this as well. But everything, all legal processes were covered by us at the jail.
Okay, so yeah, if officers do this all the time, they get what are they called? Like the 3-part copies where you write on the top copy, it goes through all the copies and you just separate them into where they go. That's a normal part. Like one part of it, we actually just got around all of this by immediately throwing the person's copy of their report and their warrant. We put that directly in with their property so that when they left, the copy went with them wherever they went. Carbon copy, that's what I'm looking for. But yeah, you don't have any evidence. Ooh, did you have any evidence that my BAC was over the legal limit while I was driving? And it's like, well, no, I wasn't on the boat with you and couldn't PBT you while you were driving. It's just like, well, we had enough evidence to think you were to initiate a traffic stop. Or a traffic stop, Jesus, this is a weird boating one. But yeah, it's like, well, we just have the probable cause that you are drunk, and that's why we're here. And it's like, you won't have evidence while the officers are in another boat. Like, it doesn't make sense.
Is it common procedure to not sign an affidavit that goes with the warrant?
I'm sorry, what do you mean by that? All my affidavits are all signed.
I'd like to submit exhibits from my motion to suppress. Exhibit 4, all 3 pages of exhibit 4 into evidence.
That's the warrant.
It's well, I didn't have a copy of the warrant. It's just unsigned documents that are supposed to be accompanying the warrant.
So exhibit 4 to your motion was it says warrant felony, and then it's got the signature page with no signature and the return that's not filled out.
Yeah, and actually exhibit 3 also, the affidavit of probable cause is unsigned.
Okay, the affidavit of probable cause exhibit 3. All right, and that's the 2 pages. Any objection to the admissions of those pages? We'll mark it as defendants A. No objection. All right, complete the list and mark it as defendants A. All right, that'll be admitted. I'm sorry. All right, so those documents are admitted into evidence, Mr. McLeod. Can you redirect?
No.
All right, thank you, Officer Bourgeois.
Thank you.
Further testimony needed from him today?
No.
Okay. All right, argument on the motion to suppress the chemical test results, Mr. McLeod.
Well, I've already shown that the warrant's invalid. It's got unsigned documents that are supposed to be accompanying it. So I would say that it should be upheld, that this warrant was invalid. It was executed improperly. It was not served on me. It was not given to me by release. It was not found in discovery with 3 requests. So it's very convenient that it turned up Friday.
All right, thank you, Mr. Juliet.
Just briefly, just based on, I understand the court has to make a credibility assessment here on whether the officer did in fact type up a search warrant and serve it on the defendant. He certainly had probable cause to draw blood. That's common procedure when somebody refuses a chemical test. The defendant displayed signs of intoxication, which led to the arrest for voting under the influence. He refused a chemical test. When offered one, based on the observations of the officer, he had probable cause to submit for a search warrant for blood. He did that. He typed out the affidavit, and it looks like, to me, it looks like it's electronically signed. On defendant's exhibit 3, he said that he served it on the defendant, left it in jail. So I would ask the court to deny the defendant's motion.
All right, well,
Hold on real quick, Your Honor. This officer never expected to be in such an absurd case when he went into whatever division he's in. Ooh, 1000%. I'm not going to lie. The conservation officer probably thought, okay, I'm going to be doing XYZ. I'm going to write some nonsensical tickets. Well, not nonsensical, but boating tickets, random hunting violations, fishing with no license, those type of tickets. He's qualified to do drunk driving and drunk boating, apparently. He never thought, oh yeah, I'm going to go to court, have a sovereign citizen just all the time. The prosecutor probably never thought, well, I'm going to go in on this day and have to deal with a sovereign citizen who has no fucking clue what he's doing in court. He's just going to, Even the judge, I know he's dealt with the earlier sovereign citizen lady, but I feel like you don't go into any of these fields or any of these professions thinking, I'm going to deal with extremely uneducated sovereign citizens. I don't think anybody, thought that going in.
the motion was to suppress results of the blood test for alcohol in Mr. McLeod's body because the blood was drawn without a warrant. Based upon the officer's testimony in People's Exhibit 1, that blood was in fact taken pursuant to a search warrant issued by a magistrate. So therefore, it didn't violate the Fourth Amendment. The complaint and affidavit and warrant that the defendant's referring to are the charging documents for the issuance of the charge. That doesn't have anything to do with the drawing of the blood. There was a warrant for the drawing of the blood, and it was drawn. And the officers testified that they did leave the warrant and tabulation and affidavit. Whether that got him or not is frankly immaterial. Even if it didn't, that doesn't invalidate the action of drawing the blood. That would violate the Fourth Amendment if it was done without a warrant, but it was done with a warrant. So that motion is denied. Mr. McLeod, you also have a motion to dismiss on procedural grounds for a probable cause conference not being timely held or validly waived. Any additional argument you want to make on that motion?
Yeah, the waiver was supposed to be signed by both parties. That's state law, and only the prosecuting attorney signed it. And then neither my defense attorneys or myself signed it.
What you could do, Vince, is make a killing as the only thing that your business would sell is slim fit judge's robes. You'd make a killing. And would this be a new subspecies of frauditor? So from what I'm taking from this guy is that he's almost a mix between a sovereign citizen and a Moor. But instead of saying, oh, I'm from Morocco, he's saying I'm Native American. Therefore, I can drink and drive like that. It's not how any of that works. Like there can be XYZ treaty out there, but driving while drunk is driving while drunk.
I'm just curious how that transpired.
Hey, Mr. Juliet.
Just briefly, I did submit a response to this, and I did research the case law on this. I did confer with district court. It doesn't look like a probable cause conference was held, but I did read the case cited by the defendant in his motion that dealt with the failure to hold a preliminary examination within the statutory time period. That doesn't warrant dismissing the case. If anything, that would call for a remand, perhaps to district court.
Remand back to district court.
But in this case, and in the case that I cited, there has to be some showing of prejudice by not holding the preliminary exam or probable cause conference by analogy. In this case, there was a preliminary exam that was held and it was bound over by Judge Visnot. So I don't think there can be any prejudice by failing to hold a probable cause conference.
All right, yeah, Mr. McLeod, the purpose of the probable cause conference is to see whether somebody wants to run the prelim or waive the prelim to address any bond issues. You were already free. You weren't being held in jail, and you did run the prelim. So there's, even if a probable cause conference wasn't held, there's no
Probable cause
prejudice.
conference is going to stop a lot of those procedures because the probable cause is all hearsay.
No. But see, probable cause conference, the prosecutor doesn't have to prove probable cause at that hearing. They have to prove it at the prelim. The probable cause conference, it's maybe not a great name for it, but that conference is just to address, are we running a prelim? What issues might there be at the prelim? Should the defendant be released
Good
from
old
the jail
Deborah.
pending the prelim?
But does it not still need to be waived by both parties?
It does, but the fact that it didn't has no prejudice to you. So defendant moves to dismiss the case on the ground the probable cause conference was not timely held and that it was not validly waived.
Actually,
I'm making my ruling now, Mr. McLeod. Defendant relies on People v. Weston involving the failure to timely hold a preliminary examination for an in-custody defendant. His reliance is misplaced, however. In People v. Crawford, the Michigan Supreme Court held that the Weston remedy must be invoked prior to the preliminary examination being held. In any event,
So for those of you who don't know what some people are talking about in the chat, Deborah was a person who got charged with drunk driving, who Chili thought he could get her out of it. And then she just ended up being dehydrated for weeks at a time.
Weston did not address probable cause conference, which did not exist at the time. The probable cause conference is to address possible plea negotiations, bond matters, and the scheduling of the preliminary examination. Defendant has shown no prejudice, even if a probable cause conference was never held and not validly waived. Moreover, defendant exercised his right to the preliminary examination. Dismissal is an extreme remedy, and defendant has not shown that it is warranted. Accordingly, his motion to dismiss is denied.
you say exercise my right to preliminary. Wasn't that kind of a forced situation under duress and threat of arrest?
It's your right to have a prelim, and you exercised it. So you exercised a right and it was held. So there's no harm to you. You exercised a right. All right. Now you filed a second motion to suppress based on lack of sufficient basis for law enforcement officer to make contact. I'm not entertaining oral argument on that motion. It's just a repeat motion. Defendant moves to suppress evidence and dismiss the case based on a lack of sufficient basis for the law enforcement officer to make contact with him and a lack of evidence of his intoxication or impairment. This motion essentially raises issues that were argued in defendant's first motion to suppress. As explained previously, the officer had legitimate grounds to approach defendant based upon his observation of defendant operating a marine vessel with expired registration upon initial.
Okay, so this might be going back a little far. Does anybody remember if they said what I guess he didn't blow, what his BAC was when they got the blood back? Or when they got the results of the blood draw back? Because that would be interesting for me to find out what he actually was. And then Lurker won. Oh, dear Lord, for 5 memberships. Thank you. Yeah, that was always my favorite thing when they would when the results for everything came back, because you kind of had a feeling like, hey, they're going to blow this. And then randomly it would be like, oh, yeah, you should definitely be like lying there, not able to move. You're that drunk, but you're somehow walking around like normal. I just want to know if he was this drunk or like this drunk.
Initial contact, the officer detected signs of impairment Therefore, both his initial contact and his investigation were entirely lawful. Accordingly, defendant's second motion to suppress is denied. Mr. McLeod, you also filed a motion to reconsider the reconsideration. That's not really authorized in the court rules. I'm not entertaining oral argument on that. Defendant moves for reconsideration of this court's recent order denying his motion to reconsider this court's denial of his motion to suppress evidence for an allegedly illegal police contact. As the moving party, defendant bears the burden of demonstrating a palpable error by which the court and the parties have been misled, and that a different disposition must result from correction of the error. Moreover, a motion for reconsideration which merely presents the same issues ruled on by the court, either expressly or by reasonable implication, will not be granted. Defendant essentially raises the same issues that have already been briefed and argued. Defendant has failed to meet its burden of demonstrating a palpable error. Accordingly, the motion for reconsideration is denied.
I think you're failing to notice or recognize the lack of jurisdiction that you have in this.
Well, that brings us to you filed three more things, and I want to address those today because today was the motion cutoff. So you've got a motion.
And I don't consent to that anymore either. I need more time to file these motions.
Nope. Today's the motion cutoff. You filed three more. I'm going to hear them today. You have a motion to dismiss for lack of jurisdiction. We've addressed the jurisdiction previously.
You don't have jurisdiction.
I already ruled that I did. This motion,
You have your own jurisdiction.
this motion is denied. This court does indeed have subject matter jurisdiction over the charges by law.
There's no or subject matter jurisdiction. I object.
Your objection is noted and your motion is denied. All right, you filed a motion for disclosure of bonds. I don't even understand what you're talking about. in that
I don't
motion.
know. Somebody else handled that.
What's that?
I don't understand.
You don't understand either? Okay. And that motion is denied. It's legally nonsense.
Yeah, that's one that killed me too. Don't give, let's walk that back a little bit. Don't represent yourself if you're going to be handing in documents that somebody else wrote. Yeah, he doesn't understand his own motion. It reminds me of the guy who was just in court. He's been in Detroit and I think he's seen Judge Washington and Judge Slavin. Let me see here. It'll come to me. Eric Martin. Eric Martin handed in some nonsensical motions in Judge Washington's court. And the prosecutor there was like, yeah, you handed in a bunch of nonsensical Supreme Court decisions. Most of them don't apply to the case that we're talking about, and other ones don't exist at all. Maybe you should actually read through and research your own evidence before you hand it in to us. That's what this reminded me of, because he basically just went, I didn't write it. I found it on the interwebs, like Chat GPT did it for me.
All this.
And Mr. McLeod, you're filing, I mean, I'm letting you represent yourself, and you're filing motions that you're telling me today you don't even understand. That's not a very responsible way to proceed. There's also a motion to recognize your subrogation rights. I have no idea what you're talking about. Do you? Can you explain it to me?
It's not necessary.
That motion is denied. It again is legal nonsense.
Yeah, he just didn't want to say,
Time for
I don't
motions
know
has
again.
come and gone.
I don't consent to that.
Well, you don't have to consent to that. I gave you a motion cutoff. All the motions have been denied. Now is the time, Mr. McLeod, where you have the constitutional right for a jury trial. So I can set this trial for, would 2 days suffice, Mr. Julia?
I think we could probably do it in one day.
All right, well, just to be safe, we'll schedule it for 2 days then. I can schedule this for a jury trial, Mr. McLeod, on Thursday, Friday, August 8th and 9th. And what we'll do is we'll be here Thursday, August 8th to select the jury. And then we'll go immediately into the trial. As needed, we can, we'll continue into Friday. I'll have you both file witness and exhibit lists within 21 days of today's date. Also, I'm going to have you file any side that wants to. I mean, the people have to. If you want to, you can as well. Proposed jury instructions by 21 days from today.
I motion to stay the court while I leave to bring this into the Western District Federal Court where it's supposed to be held. There's questions that you're answering, having opinions on that you don't have the jurisdiction to have answers. I brought that up in several motions and you keep claiming that you do. It's clearly written in the consent decree that you don't.
That's manifestly untrue, Mr. McLeod. I mean, the consent decree doesn't mean that you can drive around on a boat drunk. And if the police catch you doing that, that comes in state court. It doesn't come in federal court.
Aren't you supposed to be an unbiased participant?
I am unbiased. You may not have been drunk. That will be for the jury to decide. I'm just saying I have jurisdiction over that allegation. It's not a federal crime.
You're interpreting the fact that you're trying to say that I was supposed to notify him that I'm Native American, and that's not true. And that's your interpretation. You have an opinion.
All right, that's fine. And if I'm wrong, another court can tell me that
So I
I'm wrong.
want you to stay the court so I can take this to the proper court for an opinion on what you're trying to have an opinion on that you're not allowed to have.
Denied. You can go to that court, and if they stay it, they'll stay it.
Okay.
So what we're gonna do is we're gonna have, within 21 days of today, both sides will file jury instructions and witness lists and exhibit lists for trial. We're gonna come back for a docket call on May 28th at 9:30 in the morning in person here in the courtroom. And jury trial is scheduled for August 8th and 9th. Anything else today, Mr. McLeod?
That's fine.
All right, well, you don't, I mean, I'm giving you your jury trial, right? So you can have a jury trial. The jury's gonna decide if you're guilty.
Trial by jury is what I require.
What's that?
Trial by jury, correct?
Yes, it's trial by jury. Yeah. All right, anything further, Mr. Juliet?
No, thank you.
All right, have a good day.
Okay, so let's talk about that for a second. So this reminds me of, I was just actually having this conversation with a few other people the last 2 days. If you guys recall, there was that frauditor. I'm drawing a blank on his name. I've been doing that lately. There's just so many of them at this point. The one that beat up the old guy who had the video taken down. People were asking me, like, what do you think? Like, do you think the older guy will actually get charged and convicted with anything? Absolutely not. Jury trials don't work in these people's favors because they're idiots. What about trial by combat? Oh, I wish. I bet you prosecutors wish that was trial by combat. But anywho, it reminds me of a Carolina frauditor. If you recall, this was a long, long time ago. He went to like a pizzeria that was next to a hardware store. He pissed off a guy so badly that he went and bought black spray paint, came back and sprayed over the guy's camera. Well, the cops gave the guy a ticket. It is what it is. Well, it went to a jury trial. The jury trial went like this. Okay, well, he did this, this, and this, and then this guy sprayed over his camera. And the jury went, yeah, not guilty. Bye. And then half the town was waiting in the parking lot to beat the shit out of the frauditor. And the cops were out there and were like, yeah, you probably shouldn't come back, sport. That's how jury trial runs for these people. Because they look at the totality of the circumstances. If you come to a random city that it could have been NC Tyrant Hunter. But if you go to a town where you have I don't want to say any business being there because you can go wherever you want, the right to travel and everything. You can go wherever you want. But let's say I go to a random city in the middle of nowhere that I've never been, don't have any family, don't have any urge in moving to, yada, yada, and you try to start problems. Obviously, the people in that city is going to say, yeah, we don't like you being here, so we're just going to keep ruling against you. Sorry. And that's what happened. Like the cops, it's not prejudice. It's the cops were out there with 50 people saying, we don't like these people. We're going to beat them. And them saying, yeah, you probably for your own safety shouldn't come back. Especially in the South. I don't want to say there's more common sense down there, but it's just like you get away with more common sense shit. Another one. The guy that shot the prankster, what was he, like a DoorDash driver or something, picking up food? Guy was doing nonsense, got shot, and the jury goes, yeah, he's an idiot. That's not guilty. Sorry. So you can start problems where you live. No, I just feel like the people that it was Lizard Media. Is that the guy who beat up the old dude? I wouldn't say start problems where you live, but I feel like if you start shit near where you live, the consequences will be higher because they can literally screw you. Oh, it was poor dirt farmer that got painted. Amazing. But if you shit where you eat, what's that guy from Vegas who had the crazy name, who ended up being on the registry because he was trying to film kids from his window. Yeah, your neighbors aren't going to like that. Your neighbors can make your life a living hell legally. So I wouldn't suggest doing it where you live, but people that don't know you are going to support their neighbors, going to support their friends, going to support their family over some random guy that just came to their town to start shit. Oh, God. Oh, this right here is a heartwarming story. There was a father in Louisiana who was found innocent for shooting his son's molester dead in front of, yeah. And I have no problem with that. Yeah, no town, especially a small town, is going to be like, yes, please come to our town, harass our residents. Like, nobody's going to be like, yes, you're in the right, Mr. Frauditor. All right. Okay, so this is going to be the question portion of this. Have I desynced at all video to voice wise? Also, if you notice, the fish are actually fishing today. They're actually moving instead of just floating around doing nothing. Yeah, I just want to know if I desynced at all. Because even now, it's not sounding like a, rocket ship trying to take off from Mars, like my other laptop. Oh, okay. All right, close enough. All right, it's been like, what, an hour? Synced. Solid. Seems fine so far. Okay, so I'm probably going to hop off here. Oh, shit, you know what? Oh, Vegas Jaden. Yeah, he's got like this gigantic name, and it's like, dude, no one's going to find you on YouTube if they can't just easily put your name in. Did I decorate my office for my carnival? Let's see. I have a TV, a fish tank, a fancy Navy American flag board thing someone made me, a cool painting I made, my college degree, a sailors only parking, and an American flag. I don't see how any of those things are carnival related. No, cool clear water. They weren't dead. So 3 of them are albino rainbow sharks, which just kind of chill. That's the whole thing is just chilling in the tank. And then there's like 6 other fish that are kind of small that decided to go from hibernating to actually swimming around like normal fish. And then little Steve just does little Steve things. Hey, I use it. I just haven't used it in since I put the couch down here. I'm eventually going to move it from here. I don't know if you can see there's a hook right here. Yep. Let's see. There's a hook somewhere around there. And I'm throwing that over there. Let's talk about the lizard guy. That was crazy. I haven't even watched the video. If you guys have noticed, I've been kind of not MIA from YouTube. I've just been doing shorts, and I think I made 2 videos in the last 7 days. I've just been doing 112 other things. Poor downstairs Steve needs more attention. Hey, downstairs Steve is okay. Yeah, I've just been busy. I went to Home Depot, built a garden, did a bunch of outside nonsense because it's getting to that fancy time in Michigan. 112 what? Yeah, I'm going to try to get because I just told you guys I have a dedicated streaming laptop now and a dedicated editing laptop. I'm going to have to plug in the editing laptop to make a video tonight. Get out of the basement. Turns out, Daniel, my office is in the basement. because it is the most, I don't know, I enjoy efficiency. There's no chance of a child running through my office at 11 o'clock at night. There's no chance, there's no reason for anyone to come back like a room before this. So that's why I specifically built my office in this location. Could I put my office upstairs and kick one of the kids out and make them live down here? I could do that. But because I'm a pretty decent guy, I decided I'll put my office down here. It is what it is. Yeah, I do have, let's see here. I saw it somewhere. So you have real life skills, unlike frauditors. Yes, 1000%. And I'm not a career criminal, which is pretty dope. You're allowed a life outside of here. Yeah. Some people, let's have a serious talk here for a second, guys. Some people have no business being on the internet via YouTube or Discord as much as they are. Like, some of these people need to take a break, go touch grass, all that good stuff. Kez did a 12-hour live stream marathon on April 15th. Can you beat that? Absolutely not. I could not beat that even if I wanted to. I could not. I think I've gone 6 hours, 7 hours. Could not do it. Wait until I raise the next generation goth kid. I mean, between the 5 of them, there's probably going to be one, right? Okay. All right. You miss your squirrels. That's fair. Me and my squirrel that lives in the tree in the front yard are currently at odds. Me and Carl have been fighting the last week. But yeah, I'm going to hop off here. Everybody have fun. Do what you do. I know there's a ton of, or hear me out. You could just fire up a live stream and start crying. Hey, I could do that. But yeah, I'm gonna hop off here. I'm gonna try to edit a video or two for hopefully one for each channel, and then the third channel can just sit there in obscurity with 85 subscribers. No, his name's Carl, not Tree Steve. What do you mean? What's up with the lighting? My lighting's pretty fancy there, bud. Like, I've got all sorts of lighting options. It's pretty awesome. Having a rave down here. But yeah, everybody have a good rest of your day. Don't do anything crazy. Don't be a sovereign citizen. Don't be a Moor. Don't be a frauditor that comes with 1.5 million charges. And above all else, F David Finkel. That little meth mouth moron. Who knows, right? Carnival lights, they're called LED lights. I know they're probably before your time, but yeah. Yeah, everybody have a good day. Bye.